jury sat in that jury. So, the court can say, we would prefer this to be the rule, but Supreme Court let us. And if you don't do that, the only way to get around that, in my estimation, would be to try to find a way to distinguish this case because of the civil versus criminal context. And again, I don't see how the court can do that, given the fact that the impartial jury is a right that inures to both civil and criminal parties. But if you were to do that, then I think you'd have to certify conflict with the cases we've cited, because they do, in fact, hold just the opposite. And I don't think you can factually distinguish this case based upon what Judge Jay said on the issue of striking the alternate, because, again, we don't know what happened to those cases. We don't know the scenario. And frankly, because peremptory challenges are not all equal, and because they have a right to do that, to use the peremptory, they should be able to do it.
Do you think
and finally, I would say that we have a bright line. Did I interrupt you? I'm sorry if I did.
No, I just one question before, because we're getting close to your 5 minutes. Do you think the Supreme Court has the power to create a substantive right, like a right to a peremptory challenge by rule?
I mean, I think they create substantive law all the time, and substantive rights. I think they can interpret. I don't think that we're dealing with I think the right exists to an impartial jury. I think what the peremptory challenge is a tool to ensure that. So I don't think the Supreme Court is creating a right to its peremptory challenge as much as it is saying that in order to effectuate the right to an impartial jury, we're going to allow the parties an equal number of peremptory challenges. So I think in that sense, the answer is yes, but I don't think you have to get there in this case, because I don't think that's what they're doing.
Let's say the rule didn't exist that establishes peremptory challenges in civil trials. And the legislature, which repealed the statute in 1973, let's say the legislature just repealed the statute establishing these peremptory challenges, and there's no rule. Do civil litigants have any less of a right to an impartial jury, and are they deprived of an impartial jury?
They have no less of a right to one, but they would have lost one of the major tools available to them to do that.
But that wouldn't have any constitutional implications, though, if the legislature if it was just taken away, right?
I think that's a fair statement, because there's no constitutional right for that. Obviously, we're dealing with quite the hypothetical, which I understand the court is allowed to ask. And I want to say one more thing before I sit, and that is that the other thing about this rule that exists in Matarens and also all the civil cases that I've cited, and again, just the four I cited yesterday would be enough to certify conflict, is it is a bright line, simple rule that applies equally to plaintiffs and defendants. And if you look at the cases we cite, it really is a situation, unlike in a criminal case where it's almost always the defendant obviously was dealing with that issue on appeal. It goes both ways. I'm not sure I've ever had a decision come out before where I didn't get more phone calls and emails from people on both sides saying, file a motion for rehearing, which is kind of why I'm here. Because it is an equally applicable rule that does not favor one side or the other. And I think that is the other reason that it's an important rule. At the time of this trial, counsel was operating under the guidelines that the cause challenge, because he did all the things you're supposed to do to preserve it, that he was properly preserved, ready for appeal. He had no way of knowing that by exercising his right to that alternate strike, he would therefore waive that right, because there was no case law that would suggest that at the time. So for that other reason, I would suggest that the court doesn't need to even certify this case or conflict, should just simply withdraw its opinion and reverse the judgment. But if you're going to stick with the opinion and reasoning, we think it has to be taken up by the Supreme Court, either on a certified question or certified conflict. So I'll reserve my last 2 minutes. Thank you.
Thank you, Mr. Bell. Mr. Tinker.
May it please the court, good afternoon. Mark Tinker on behalf of Marina Bay Resort. I'd like to address, I think, there are two terms that have been used quite a bit that I think are important. And one of them that has been said a lot and is the subject of the questioning is that there's a right to peremptory challenges. And there is no right to peremptory challenges. That is one of the questions, obviously, the court asked and counsel conceded. There's no constitutional guarantee to it. It is contained in the civil context, unlike criminal. It is in the rule of procedure. It is the rule that governs jury selection in general and selection for jury trials. And under established law, it's a separation of powers issue. A rule of procedure cannot enact substantive law. In the criminal context, we have a statute that gives a substantive right to jury selection in accordance with the statutes. In the civil context, there is no statute. A rule of procedure can govern the procedure that the judges use while performing jury selection, but it cannot enact a substantive right. And that leads to the second issue is the argument that was raised is, well, this is, in the criminal context, it's per se reversible. And I don't believe that's accurate either. There is no per se reversal that happens for issues in jury selection. That's true even with challenges for cause. If that's actually the entire basis for the preservation requirement that a lot of courts call it the Trotter test or whatever you want to refer to it, is if there's a challenge for cause that is wrongfully denied, so we have a judge making an error, that there is still more that has to happen to preserve it because you have to show that there was harm. You have to show that, well, this objectionable juror that the judge should have gotten rid of sat on my jury because I was unable to strike them. So you have to go through the exhaustion of the peremptories and identifying the additional juror. That's the whole basis for the test, is the second component, that there's an error and did it harm me? So there has to be a harm component with cause challenges. The same is true with peremptories. A lot of times peremptories are referred to as, well, they can be for any reason. That's not exactly accurate. We know, and I believe Busby speaks to this, is you can't say I'm striking that juror, that prospective juror, because they're black. That would not be a permissible use of a peremptory. So it would follow from that, if a person uses all the peremptories and they go through the Trotter test and they want to preserve the issue and they say, I'm harmed because if I had one more peremptory, I would have stricken that last black woman sitting there. That wouldn't establish harm because that would not be a proper use of the peremptory. So we know that there's a harmless error analysis that applies in both contexts, including in peremptories. And that's what this court applied in its opinion, looking at the procedure that occurred, looking at the jurors that Seidler found objectionable, and said...
What do you do, though, with the argument Mr. Bell just made, that this trial lawyer is in a very difficult position, based on our opinion, when they evaluate whether to utilize an alternate strike, and prospectively, that lawyer in a similar circumstance may be reticent about doing that, given the fact that that may be seen as a waiver. How would you respond to Mr. Bell's argument in that regard?
It's a difficult position for the lawyer, and it's one that's virtually impossible to address in this setting because we don't know the reasons that are being applied. We don't know why strikes are being used the way they are. The only thing this court has before it is the record of how strikes were used and the identification of prospective jurors that it would have been used on. So we don't know the reasoning. We don't know if the counsel would have made a different decision knowing that this was going to occur, if it would not have identified that juror as someone that they were going to strike, if it would have identified to the judge, had you given me an extra peremptory, I would have used them in this different order. If something like that, I mean, we can't get into the minds of what trial counsel was doing. The only thing the court has before it are the facts that we know that by the process as it played out, that the objectionable juror was going to end up on the trial court anyway, as part of the 6 jurors. And as counsel conceded, it was, as far as we know, it was not it was an unbiased jury. It was an impartial jury. There are no issues that arose from the jury that was actually selected. So it's getting into, can we get into the minds of trial counsel as he's making these selections? And can we say, well, if they'd known this, he would have used that alternate peremptory differently? I don't think that there's any way to do that on appeal.
Mr. Bell also said, given the state of the law at the time, Matarance, this lawyer did exactly what Matarance said he needed to do, which was voice his objection to the fact that the court didn't grant the for-cause challenge, and then ask for an additional peremptory. And little did that lawyer know that we would find this significant, dealing with the miscarriage of justice. But again, following the algorithm of Matarance, and here we are affirming, is that an issue for us to consider here on rehearing?
No, and I'll say I've said before that I thought there was a 2-step process. I'll make it 3 steps now. Is did the judge make a mistake? If the judge made a mistake, did we preserve it? That's what Matarance says, and that's what your question goes to. Did counsel go through and preserve it? And then number 3, was there harm? That's what this court's decision, what the opinion was based on, looking at the manifest error statute, saying based on what the facts are in the record before us, we know an objectionable juror would have been on that jury anyway. So this well, I actually have it down, this denial of a challenge for cause, if wrongful, I don't believe that the opinion actually establishes that. It says perhaps. I know, I believe your question earlier kind of said if we assume, so that decision was never actually made if this was a wrongful denial of a cause challenge. But
Does that matter to us? I mean, there is, perhaps, one word. Does it matter if we found or not that this was error?
It doesn't to the, if you found that it was a harmless error, then it doesn't matter. It matters a great deal if you found that the judge did not abuse his discretion. If Judge Stone was correct in his decision to deny the cause challenge, then none of this matters as far as if there was no error, there's no reason to assess whether it was harmful or not. So yes, it matters, but no, it doesn't for the basis of the opinion, because the opinion assumes, if we were to assume that it was error, let's just say that it was at best harmless error, was what the opinion is based on. So long answer to a short question, no, it doesn't matter for the opinion, but if you decided the judge didn't make a mistake to begin with, then yes, it would make a big difference, because it would mean that the court should affirm for that reason.
Doesn't the Trotter test in this business about preservation, you know, and the sort of this calculus or this routine that a lawyer has to go through just to preserve the for-cause challenge, doesn't it just make sense in a situation like Townsend, where the number of for-cause challenges or objectionable jurors that would be for cause outnumber the number of peremptories in the first place? You know, and like Townsend, they had, 8 that they wanted to strike for cause, and they could only get to 4, you know, the judge denied them, and they used the peremptories they had to strike what they could, and they didn't get enough peremptories to then get rid of the others. So you had objectionable jurors on the panel, ultimately, which then understandably, you know, that's a contention of error, because you don't, if they're right, then now you don't have an impartial jury. Is there a fair distinction between, you know, what was going on in Townsend and the preservation required there, and sort of the situation here where the objectionable juror did not serve on the jury?
I think that there's a distinction, but I think what Trotter does is actually describes what this court did in its opinion. Is Trotter says if there's an error, the judge has made an error in denying a cause challenge, then a peremptory can be used to cure that error. And if the party has extra peremptories left such that they weren't denied any extra peremptories, then that solved the problem, and it's harmless error. So we get back to the harmlessness again. What this court did is looking at the same situation, saying if there was an error, in order to cure the error, you prevent having an objectionable juror sitting on your jury. You've asked 2 questions here today. The first was there any evidence that there was an actual biased juror on this jury? No, there was not. Was the party denied a peremptory challenge to get subjectively someone that they didn't want on this jury removed? No, they were not, because that person would have moved on to the jury and would not have been strikeable anyway, because they would have been out of their challenges by the time that this, or 12, I believe it was, would have moved on. So what Trotter is describing is, again, it's going to, is there harm? Did you end up with a person? And I wrote the quote down. Mr. Bill stated, if there was a person that I wanted to have stricken that sat, that's my harm. Well, here, a person that they wanted to have stricken would have sat regardless. That is what this court's opinion says. So that's where, the entire Trotter analysis is to prevent, can we cure the harm? Here, it was harmless because the objectionable person would have moved on to the jury anyway.
Well, let's critique our opinion a little bit while we're at it. And does it even matter? Like, does even that analysis matter? Do we even need to get to whether the alternate juror would have, sat, or, you've seen the permutations that we went through. If Mr. Seeler got 3 peremptories, which the rule provides for, and he used 3 peremptories, and for whatever purpose, so, it served at least a purpose. It got the objectionable juror off the panel, and it presumably would save a fair amount of time. You wouldn't have to do a new trial if they otherwise were right, that the juror was not impartial. Where is the harm? I mean, at that point, even if, an objectionable juror that they would have stricken that they wish they could have stricken, not for cause, but just otherwise. How is that harm? And does the preservation rule anticipate that it actually is harm, like in a civil case?
I think that last word is what changes everything, because and it goes to the questions that this court asked in the oral argument notice is, in a civil case, no, because there is no right to peremptory challenges. That's where I started my argument. If you look at Matarance, they say the harm is that if you're allowed a certain number of peremptories and you're forced to use one that you shouldn't have had to use, you don't get what the statute allows you. Well, in a civil case, there is no such thing as the statute allowing you those peremptory challenges, and as I said, a rule of procedure cannot create a substantive right. So that's the big difference. I know the court asked it in its questions, is that, and when we're talking about the civil context, I believe all of the rules in the cases that we've looked at in Matarance and in Busby, they all look at it and say, because of this, you were denied the right that the statute provides. In a civil case, there is no such thing. So I believe if you are left with what the court looked at its opinion, the harmless error statute, and to say, was there a manifest injustice that occurred here? And I agree with the court's analysis, obviously, that did not occur. And, counsel said that there was an impartial jury that served. They used their peremptories. They ended up with a jury that they would have had somebody that they deemed subjectively objectionable on it anyway. So I don't believe that the court can say there was a manifest injustice that occurred.
Right, but going one step further, though, so let's say let's say there wasn't that alternate juror that would have served anyway, so that and it was just a question of whether, okay, this person for cause should have been stricken for cause. The person that was stricken as a peremptory should have been stricken for cause. So they had, they used a peremptory to cover that. And they were just coming in and arguing straight, like, hey, we get a new trial because we had to use one of our peremptories. And we look at it, do we have to go that extra step and look at whether there was a miscarriage of justice because someone would have served anyway, even if they were given a fourth peremptory?
Well, your question is why I said I think that to call it per se reversible is a misnomer, because your question would ask if they had to use a peremptory on someone that should have been stricken for cause, does that end the inquiry? Should that be it? And if it was per se reversible, that would end the inquiry. But we know it doesn't, because the Supreme Court has told us you have to go through and show harm. You have to show that you exhausted your peremptories because you had to fix the trial judge's error. You have to specifically identify a prospective juror that you would have stricken and show that that person actually sat. So it's going through saying not only can you do this in a vacuum and say, oh, the trial judge made a mistake, new trial, you have to specifically identify who the juror is that you would have stricken. And if there's no purpose for that requirement, if not so that the court can look at it and say, was it because I wanted to strike the black woman from the jury? The court can look at it and say that wouldn't have been a proper use, that did not cause any harm, and therefore, even if the trial judge made a mistake, it was harmless.
Well, what if their claim was just, I would have stricken that person. I didn't like the color of his tie, to use the example from before, and I want a new trial because that person served on the jury, and if I had the peremptory that I shouldn't have had to use, then that person would have served. And so that's my harm, is that the person that I intuitively, I can't articulate the reason why I don't want this person on my jury, but I just know that I don't want them on their jury, and that's my harm. Is that a cognizable harm in this analysis in a civil case?
I don't believe so, because of the issue that it's not a substantive right. It's not conveyed by statute, and the thing that the statutes do provide is the harmless error analysis to look at if there's a manifest injustice that occurred. We know, based on the jury and based on the concession that it was a proper jury, that no harm occurred. And I mean, we're getting into hypotheticals now of what might have happened, but we also do know on this record that an objectionable person, if we're talking about whether it was the color of the tie or whatever it might have been, we know that person was objectionable to the point where Seidler did not even want them to be an alternate and risk that they might move on to the jury at some point. They wanted juror number 12 gone. So we know that that's an objectionable person, would have ended up on the jury. From there, I don't believe that you can get past the fact that it's not a manifest injustice, that there's no absolute right to the strike, or to do an extra strike in order to strike someone because of the color of their tie. I believe that's all the notes that I had, unless the court has any other questions. I just yield the rest of my time.
Thank you, Mr. Tinker.
May it please the court, briefly, I think counsel said something very important there when he said that it's impossible to answer one of the questions because we can't get inside the lawyer's mind. And we also can't get inside the juror's mind to determine their partiality, which is why the Supreme Court set this per se reversible rule that we talk about. Obviously, the juror has to serve. It can't be somebody that's like an alternate, doesn't go back in the jury room. The Frazier case from the 4th DCA discusses that. But in this case, we had a juror that we didn't want on the jury that served. And the Supreme Court in Busby declined to differentiate between cause and peremptory challenges on that basis. They said on page 97, we declined to modify the Trotter standard based upon our determination that the Trotter test is necessary to properly protect the right to trial by an impartial jury accorded to every defendant in this state and to effectuate the statutory scheme granting peremptory challenges. Yes, I recognize that's criminal. Yes, I recognize that's statutory. But what's happened is all 4 of the other DCAs, and I don't know if this, I could not find a case from this court on this fact pattern, so I confess that I'm dealing with other DCAs here. But there were 8 cases that I found, I'll read them now to you, that all held under the exact same scenario we talked about, that the failure, the fact that a person that you could not strike peremptorily served on the jury is reversible error per se. I'd read the Coachella case, which actually used the word per se, but we have the Pearson case from my motion for rehearing at the 2nd DCA. The 3rd DCA, I found 3 cases. The Rivas case from the authority yesterday, Rodriguez case from the motion for rehearing, the Tizon case from the rehearing motion, the 4th DCA and the Bell case, which we filed yesterday, and the Weinstein case, which we filed in the motion for rehearing, and the 5th DCA and the Guti case, which we also filed yesterday. All 8 of those cases held that when you have to use a peremptory challenge on somebody that should have been removed for cause, and that and somebody else sits that you don't want to sit in the jury peremptorily, it's reversible error. So for that reason, we ask the court to either withdraw its opinion and reverse for the reasons we stated initially in that brief, or at a minimum to certify a conflict or a question of the Supreme Court. Thank you.
Thank you, Mr. Bell.
Thank you.
The court will be adjourned.
All rise. We'll see you. You having a good day? Yeah, are you having a good day? Better than yesterday? All right. All right. Yep.